Hey guys, I recently just got my trademark through for one of my companies, and it was a hell of a process. So I thought I would make a video about why it's important to get a trademark. There's this whole new Take a Lot brand program. I've been doing a bit of reading into it. It's still very new, but it's only going to be eligible to those brands that are actually registered with a trademark. So there already is a massive point to go get it and to start it. So anyway, I'm not an expert, and to be honest, I don't really know much about the whole process. So what I did is I invited someone to come give us a little bit of information, and this is pretty much how it went. Hi, Kyle. Thanks for joining. Feel free to give yourself a quick little introduction, and then we can jump into learning a bit more about trademarks.
Awesome. Thanks, Andrew. Good to meet you. I am the CEO and co-founder of Legal Legends, which is a South African online legal services company. I'm also the CEO of Loft Legal, which is an international online legal services company that provides services in the UK, US, Australia, and Canada. But I know for the purposes of today's meeting, we're going to concentrate on the South African business and specifically the trademark registration process, I believe.
Yes. It's been quite a process, getting one for myself. I think the big elephant in the room is that it took quite a little bit longer than I would have thought. What's the current situation with SIPC and getting a trademark?
Yeah. Initially, when we started filing trademarks, it would normally take about 2 years. We do understand that with the CIPC, they had a big file transition project that they had 2 years ago, where initially their old offsite file storage providers, when they requisitioned a file, which is every time we followed up with them, it would take sometimes in excess of a year for them to get a file. Sometimes it just doesn't exist, or we follow up for 2 years and it eventually arrives. But I believe about 2 years ago, they embarked on a project of changing their offsite file storage provider to a new one. Whether or not they move the old files across to the new file storage provider, I'm not certain. It doesn't seem to be the case because it still seems like it's taking months for them to requisition files. The reality is, with registering trademarks, it can be anywhere between, we've had some trademarks that operate through in sort of 16 months, that's just purely by chance, and some trademarks which take 5 years purely by chance. And it's not something that we unfortunately have much control of, but we've tried to, as much as possible from our side, automate everything to get it through in the quickest manner possible, so at least there's no human delays or any form of a delay on our part.
I think that was probably one of the big pluses. Even across my mind, you pay a bunch of money to get a trademark, and then we hadn't met on a call before. It's quite nifty through the website. We did a lot of it quite instantly, and then you wait. And I know you guys send an email and you say, okay, I think at the time 3 months to, I think it was quite a while. So I applied 3 years ago, and I'm very glad I got it. And I was super glad I got all those updates. But yeah, you worry. So I was super glad when I got a couple updates and they started coming in more and more frequently actually towards the end, because I think a lot of people get less patient towards the end, but they kept coming in and update, and my team would tag me and be like, oh, nearly there, and the stages it's going through. Yes. So it was very, very good to see. There's a lot of peace of mind, not quite what you would expect in South Africa all the time on a service level. So very, very great experience that. But now, despite everything, despite this long process and this long wait, is it something that's worthwhile for a business to embark on?
Yeah, it certainly is, both from a defensive perspective and from an asset perspective. I mean, from a defensive perspective, if you've got a registered trademark, you are presumed to effectively have the right, in terms of the Trademarks Act, to have the exclusive or monopoly over that word or that logo or a combination of both, relative to the specific services or the specific product that you offer. It's great from that perspective because you can quite easily send letters of demand, tell people to stop using that particular name, or because it is registered, the CIPC would automatically reject any other applicants which file for a confusingly similar name in the same or a similar class. So it's great from that perspective. But from an asset perspective, if you're a business and you're ever looking for funding and you have a DD or due diligence conducted on your business, it's one of the basic questions. I mean, do you own the intellectual property that you seek to utilize, which is your name or your logo? Because if you're ever forced to rebrand, it can be a considerably costly exercise. It is in and of itself a separate asset that accumulates its own value and is investors place a lot of emphasis on the importance of it.
Okay, so first thing, it's words or imagery. So as you know, it can be in a combination of both.
Well, there are also other trademarks such as sound. You can actually trademark smells to an extent, provided you can describe it. You can also trademark the shapes of things, like the Coca-Cola bottle, for example, the shape that shape, but yeah, the shape of that particular bottle can also be trademarked. In theory, it's any sort of sign which serves to distinguish the goods or services of your business from that of another. But broadly speaking, in 99% of instances, it's a name, such as a brand name or a company name, or a logo.
Like what sort of could happen to the businesses that don't have it?
So there is something known as a common law trademark, which is effectively the right to a particular word or brand element without having registered it as a trademark. If you've garnered such substantial use of a word that people ordinarily associate that particular word with your brand, you could have some form of protection, and you could also oppose others from registering a confusingly similar name in the trademark register. However, the concern with that is the burden of proof is far greater. You need to prove that there has been substantial work put into it, and the market recognizes your brand to such an extent that you've been able to obtain a common law right to the name itself. To summarize, you're not entirely without protection.
I guess it's quite scary because you can rely on that, but you don't know who's going to come with a bigger pocket than you and say they want to claim this brand, evergreen, or some whatever kind of the more generic ones. And in terms of the cost, I didn't think it was exorbitant expenditure just to it's just part of that bundle of a startup fee. It's starting a business, and you just do it and then you wait. And I think in the meantime, while you're waiting, you can use like the TM, and then when you get it, it becomes the R, correct?
The R sign with the circle indicates a registered trademark, absolutely. But one thing a lot of people don't realize is that trademarks are jurisdictional territory based. So some people think that they file a trademark in South Africa and all of a sudden they've got the rights worldwide, but that's not the case. There are a few pacts around the world where you can file for a trademark and you have protection across multiple jurisdictions, but generally speaking, South Africa is not party to any of those. So if you file in South Africa, you have trademark protection only in South Africa.
That's actually a really good point, because I think a lot of business owners might be watching this before they at the stage of even picking their name, and it's kind of your first stage. It's like, okay, what am I going to call my company? And then there's always a company with the same name as you're thinking of. It's even happened to me recently. I've had a side thing, and it's under a new name. I went on LinkedIn the other day. I hadn't really researched. I just kind of spun the name out, and I was like, oh, there's like 4 or 5 other guys. Luckily, they all seem to be overseas. But would I still be able to, provided they haven't registered something in South Africa, I could still quite safely have a similar name to them, or maybe even the same if it's like ABC Pty Limited, and someone in America's got that. What would you say to someone thinking about that?
You can, however, if that brand, even if they are not registered in South Africa, but they are so well known to a significant number of people in South Africa, they would have protection under the Paris Convention, meaning that they don't need to register in South Africa to have protection in South Africa. But you need to be a huge brand in order to get that protection, such as Coca-Cola or Apple Computers or something like that. Yeah. Generally speaking, if we're looking about small to medium-sized businesses, you would never have protection of that.
It's almost impossible for even like the more generic the names get, we're running out of things to name companies these days. We have a bit of protection for naming something in here in South Africa, and then someone else with a copy of our brand in UK, for instance. Not a lot we would be able to do as a South African, unless we're not obviously speaking from a small business perspective, not having a massive brand. Would we have any defense?
From a name perspective, probably not, if they're just copying your name. But if they, for example, have copied the look and feel of your website, and on that basis, you would probably be able to prevent them from utilizing exact copies of your website, of your logos, etc. But the name alone will be very, very difficult to prevent them from using.
What is the things to consider when applying for a trademark, kind of trying to recall back when I did mine, and there's a couple of questions that get asked, and there's a few things like names that are obviously close or confusing, and maybe things that are like a little bit more taboo type of names, these kinds of things. So what are people to consider to make this process easy and as painless as possible?
The strongest trademarks are completely made up words. So start out with that. The more unique, the better. Because the main test is, does the sign serve to distinguish yourself from the goods and services of others? So as you become more descriptive, like describing your services, I don't know, I've got a car wash and I call it fast car wash, it completely describes your services, and that'll be rejected on that basis because it's completely descriptive. So as unique as possible. As soon as you start utilizing something which is more generic and more descriptive, you really are falling into the realm of something that's not going to be registrable as a trademark. In addition to that, just make sure you do a search of the trademarks registry. We offer a free AI search, which searches the registry and interprets the results and provides you with findings. I don't think that was available when you registered.
Probably not.
Another thing people don't realize is that the company's name register and the trademarks register don't speak to each other. So you can register a trademark, but there's a company that exists with that exact same company name.
Wow.
Provided they've got the common law right to that name, that can prevent you from successfully registering a trademark. So do a search of both databases, which is very, very important.
And I think the CIPSI is quite easy to BizPortal or one of the two. You can just type in the name and search it. And then that AI search, is that on your website? Or is Legal Legends?
legallegends.co.za, and you can just search on the search field, search basic search, and it's the free basic search that comes up. And then you pop in your name, describe your services. The AI will then automatically classify your trademark to one or more of the 45 different trademark classes. It'll then pull from our database of registered trademarks and pending trademarks. If there are any conflicting ones, it'll then determine or interpret the results and provide you with a finding over email.
I've tried to use the CIPSI search before and I gave up because you have to like go into each category, and I got to like category 6 and I was like, this is going to take all day.
It's really painful. It's really painful. And also with the CIPSI session, nothing wrong to them, but it doesn't interpret the results for you. It'll provide you with a bunch of results, but it doesn't interpret them. And that's what we try to do with the AI search, is say, well, here are all the results we unearthed. Look at those, determine from those whether you feel any are confusingly similar. If they're confusingly similar, are they close to prevent registration of this trademark? And also, if there are no conflicts to prevent us from registering a trademark, well, is it generic, the word, or is it descriptive relative to the products or services? And if so, it might be rejected on that basis. So considers all those aspects prior to providing you with a finding.
And last question, what about words that are just not, words to obviously avoid? Okay, so you can't trademark staircase and like common words like that. I think people are...
Well, in an unrelated class, look at Apple computers. You can't register Apple in the fruit class, but you can register Apple in the computers class because it's not descriptive of computers. So I could register staircase, the fruit company. One thing you can't register is bank, for example. That's a word you can't utilize. I mean, there are things such as tequila. You have to show proof that you have come from a specific region, same as champagne, rooibos. There are a few examples of those where you just simply are not permitted to register on that basis alone.
And I think words like guns and alcohol, and like there's a few sort of, obviously you can't curse words. They've got a list of like sensitive words that you can't use.
So they say that. So we've managed to register many trademarks with simple curse words in them, but not really offensive to a specific demographic. That is a theory behind it, but in practice it might be a little bit different.
I was worried about that because I thought I did one and I thought it would maybe be fringe, on a side case. And then I was thinking, okay, maybe that's why it's taking longer. Last thing, is it getting better, the time span that you've noticed? I know COVID was a bad space for CIPSI, but...
We thought it was. We thought post 2021 marks were getting slightly better, but we're still noticing a bit of a delay. I mean, you're looking at sort of currently, but it's anyone's guess. I mean, as I say, we've had trademarks registered and pushed through within sort of sort of 15, 16 months. Others which take 5 years, but it also depends. If, for example, an examiner resigns, and this is something which I had a real gripe with the CIPC about. If the examiner resigns, they don't really tell you. Second of all, you eventually do pick up on this. They say, well, they've resigned. I need you to manually deliver every single one of the applications that this examiner has for your firm to the Dropbox at the CIPC. I said, well, this is just astounding. I mean, can't I just give you Dropbox access to this? Or can't I just share? No, this is our procedure. And it's happened with 2 or 3 examiners over the last year. And then it takes a year and a half for another examiner to get assigned. I mean, they're getting better with certain parts. I mean, they have trademark certificates, which were, when they were issued, they were manual and they were sent via the post normally. There were a lot of certificates which weren't arriving. Now they've gone digital. The official actions that they used to issue were also manual. Now they're digital, so at least that's instant. So from that perspective, it's certainly getting better. But there are a lot of hurdles.
The backlog.
Backlog, absolutely. And there's probably a lot of things that we simply aren't aware of in the back end. But what we've tried to do is design processes on the front where there can't be any delays occasioned by our humans in our firm at all. Yeah. So everything that comes in is instantly analyzed, lifted by our systems, providing draft responses if necessary, or submitting them for advertisement if necessary, using a combination of headless browsers, some AI, a lot of automated processes, a lot of automated emails, just so that there's sort of a 1-minute gap between something coming in and that whatever that item is being actioned.
I've always been a big proponent and always try to tell everyone, you know, like I think one of my earliest videos is just how to do your company annual returns on CIPC. And I've always kind of said, you know, like there's a lot of things that you can do yourself as a business owner, and you should just be careful not to be taken for a ride on certain things that people say, oh, you need to do this and you need to do that. But there are a few things, and very evidently trademarks is one of those things to outsource. It takes a lot of stress off your table. It's not something that you can do as a layman. There is processes where you need sign off. You need someone. I think it just has to be a trademark attorney at some point. It was a long process. I looked into it, and I'm glad I'm glad I outsourced it. I don't think I could have ever done it cheaper myself. So yeah, very much thanks for that, and thank you for jumping on today.